name is Yogya Bhatia and I am a legal intern at LEXIS and Company. Today I'll be talking about insolvency and bankruptcy. Insolvency and bankruptcy code is the Modi government's most important reform. Indian capitalism never understood bankruptcy and moreover it is taken as a shame. This is quite wrong since a business can fail and there is nothing shameful in it. Insolvency and Bankruptcy Code 2016. The Insolvency and Bankruptcy Code 2016 was introduced to improve the relationship between the creditors and the debtors. IBC 2016 was passed by the Lok Sabha on May 5, 2016 and by the Rajya Sabha on May 11, 2016. It caused the Senate of the President of India in 2016 and after 6 months in December 2006, IBC got active. On 1st June 2016, National Company Law Tribunal and its appellate body was set up by the government under Companies Act 2013 to educate disputes in the matter of companies and limited liability partnership arising under the Act. In case of individuals and partnership, the educating authority will be Debt Recovery Tribunal, which was established under recovery of debts due to banks and financial institutions. Both individuals as well as organizations can apply for insolvency. The only difference is for individuals, it is known as bankruptcy, and for corporate, it is called corporate insolvency. It is a situation when an individual or company is not able to pay the debt in the present or near future and the value of assets held by them are less than their ability. The Insolvency and Bankruptcy Code 2016 had been enacted to merge the then existing laws related to insolvency and bankruptcy. Insolvency is a state in which financial difficulties of a company are such that it is unable to run its business. In order to cut down the burden of increasing non-performing assets, different kinds of reforms were necessary. However, an immediate change in the insolvency and bankruptcy law was important. Therefore, bankruptcy law in 2014 under the chairmanship of Mr. T.K. Vishwanath, former Union Law Secretary, was set up. In view of recommending an Indian bankruptcy code to replace the existing laws and applicable both to non-financial corporations and individuals. The draft of Insolvency and Bankruptcy Code was submitted in 2015. Key components of IBC in resolution process are Educating Authority. NCLT and DRT are judicially constituted special bodies for educating resolution of matters related to insolvency and bankruptcy. NCLT appeals lies to National Company Law Appellate Tribunal, and after that, NCLAT, the party, can appeal to the Supreme Court of India. Similarly, for DRT, appeals lie to the Debt Recovery Appellate Tribunal and then to the Supreme Court of India. NCLT and DRT are separate tribunals. NCLT is for companies and limited partnerships and DRT is for unlimited liability partnerships and sole proprietors. Committee of Creditors. Committee of Creditors is given under Section 21 of the Insolvency and Bankruptcy Code 2016. COC consists only of financial creditors. The role of the COC is to approve and disapprove the resolution plan proposed by the resolution professional in corporate insolvency resolution process. The minimum vote required to approve the resolution plan is 75% in a meeting of COC. Operational creditors are allowed to take part in the meeting of the Committee of Creditors, but they don't have their voting rights. Insolvency Professionals. Insolvency professionals are of two types. One is interim insolvency professional and the other is insolvency professionals. Interim insolvency professionals are appointed by the educating authority within 7 days from the day the application has been admitted by the educating authority, and insolvency professionals are appointed by a committee of creditors by a majority vote of 75% in the first meeting of the COC. If the COC is not satisfied with the appointed interim insolvency professionals, they can replace them by filing an application before educating authority. The educating authority then transfers the list to the Insolvency and Bankruptcy Board of India for approval of the list. If the board fails to respond within 10 days, then the educating authority directs the interim insolvency professionals to continue with the insolvency resolution process till the time the board confirms the list of insolvency professionals. Insolvency and Bankruptcy Board of India. Insolvency and Bankruptcy Board of India came into existence on 1st of October 2016 to regulate and counter various insolvency and bankruptcy cases reported by financial operational creditors, which especially involve banks in India, home buyers and etc. The IBBI falls under the Insolvency and Bankruptcy Code 2016. IBBI plays the role of governing body for all such as insolvency resolution process involved insolvency professional agency and information utilities. Approving the list of resolution professionals is done by IBBI. It also enacts rules as well as enforce them to resolve corporate insolvency, corporate liquidation, individual insolvency and individual bankruptcy as per the Insolvency and Bankruptcy Code 2016. IBBI also takes part in making new amendments to the code. Thank you.